Yes, so I suppose one thing that COVID-19's actually been able to do is allow you to go back and look over your history. And I was a bit shocked to realise that I've actually been doing this for 25 years now. I started working for Dad as a 20-year-old, and 25 years later, I'm still working for Dad. So lucky enough that for 20 of those years, I've been representing local governments in New South Wales, Queensland, and Victoria. Today, thanks for joining us in relation to the webinar on COVID-19 and how it has affected councils across all areas. Bear with me now, I'm just going to bring up the webinar. And I hope everyone can see it. Moving forward, now, debt recovery has always been a sensitive topic in local government, even before the pandemic. However, the fact that we don't know with this current pandemic when it might end or when another strain might come up, and that's completely relevant today with what's happening down in southeast Queensland. Debt recovery has become a major talking point amongst local government councils. Okay, one of the main reasons is that whilst debt recovery did cease or stop, or a lot of councils stayed their recovery action, councils were still levying rates and they were still incurring sundry debts. Okay, so debt levels were going up, interest had stopped. But it came to a point where debt recovery was eventually going to have to start again at some point in time. Now, today I'm going to talk about 5 topics. The first, I'm going to look at the strategies that were adopted by councils in different states as a result of COVID-19. I think this is important because different states have been affected in different ways. As I mentioned, we don't know when we could be in for another long lockdown in the future. Fingers crossed it doesn't happen. But I think it's important to have a look at the way some different councils adopted different policies and which policies they were happy with, or which councils would have probably preferred following a different path. So I'll talk about that. I'll then move into what Queensland councils, more back at home, are currently doing at the moment, and their current strategies and policies. I'll then look into having a bit of a chat about key performance indicators, what you should be looking to getting down to in terms of your percentages. I'll move then into topic 4, which will be hardship. Now, I'm not going to talk about whether you should or shouldn't have a hardship policy, what's in your hardship policy, what isn't in your hardship policy. I'm going to more about give you some tips about assessing a hardship policy, what the court will look at if people were to make applications to the court, and just generally a few tips that can help you out because hardship has become a huge part with COVID-19, and that is going to continue. Some industries have boomed and continue to boom during COVID-19, and some have been hit very hard. So hardship and dealing with hardship is going to be an ongoing factor in local government. And then lastly, time permits, I'm going to talk about sundry debts. I know a lot of councils really focus mainly on the rates, and that's understandable. Rates is the primary source of income for all councils, but sundry debts aren't to be forgotten because they are still being incurred and they will continue to be incurred. And sundry debts are very different to rates. Rates can be pretty straightforward in terms of the recovery, the registered owner being liable for the rates. Whereas sundry debtors, the finance department, you're really relying upon a previous department having done the things that they needed to do for you to be able to be successful in having the evidence to be able to collect that debt. So moving on, March 2020, most councils in Australia had one thing in common when it came to debt recovery, and that was it stopped, okay? Councils stopped all their debt recovery as well as interest, or they heavily reduced the interest on any overdue rates and charges. Okay, as I mentioned before though, whilst debt recovery had ceased, councils were still levying throughout the pandemic, and they continue to levy as we speak. The real concern that I found with my clients and speaking to them was from March onwards, especially for the remainder of 2020, was what was the outstanding percentages going to be when we eventually came out of the pandemic or we started to come back to some type of normality. In about October 2020, especially in Queensland, and we've been so fortunate living here as opposed to the southern states, things were going quite well, both socially and economically, okay? COVID appeared to be under control, and gradually towards the latter part of that year, my clientele started asking me a common question. What is everybody else in local government doing? Now, that was completely understandable because, as you can appreciate, local government councils, they didn't want to be seen as being too harsh, but at the same time, they realised that they had a statutory obligation to collect the overdue rates. Councils were also aware of how political sensitive this issue is, and they wanted to avoid the possible negative public perception of actually commencing the recovery of rates and charges and or sundry debts too quickly. So it became a balancing act. When was the right time to start collecting the overdue money again? So I think it's important that we go back and see what policies and procedures local government councils, not only in Queensland, but in New South Wales and Victoria, adopted when the pandemic first began. Now, I'm going to start with Victoria. And the reason I'm starting with Victoria is it has been the hardest hit, without a doubt. Having both relatives down there, having an office in Victoria, just seeing the roller coaster ride that they've actually gone on, they've really had a hard time with it down there. Now, most Victorian councils did one of two things. They either passed a resolution at a council meeting to stay all debt recovery for a significant or for a set period of time, and also suspend interest on any overdue rates. Or secondly, rather than an official resolution, they adopted an internal policy by the executive to stay all debt recovery and suspend penalty interest. Now, the second option provided the councils with a level of flexibility as opposed to the first one, okay? The second option gave the councils the ability that if things were going well, then they could look to start to gradually ease into the process of looking to try and recover some of the debt that was really starting to increase quite significantly. Now, in March, April 2020, some councils in Victoria passed resolutions to actually stay all debt recovery and interest right up until 30 June 2021. So you had on the one hand some councils that really got on the front foot and they passed resolutions for a significant period of time. Others passed resolutions on a more stagnant approach. Others, as I said, it was only March 2020. So they adopted an approach where they suspended interest and debt recovery until 30 June that year just to see how it was going, and then gradually looked at it from there. Most councils in Victoria, because they've been in and out of lockdowns, have continued to suspend all interest up until 30 September this year. That's to be in line with their next rates levy and when they're due, okay? One council even passed a resolution just recently to continue to stop interest right up until 30 June 2020. Now, in Victoria, in February this year, again, Victoria was on the rise. Now, I know Victoria's been in and out of lockdowns, but there has been significant periods of times where things were going well, and where things were going, especially in regional. Regional as opposed to metropolitan, have seemed to come out of COVID in Victoria a lot better, okay? So much so that many of the rural councils actually began some form of debt recovery in around February 2021, okay? One of my clients even went so far as to issue legal proceedings, okay? Obviously, further letters went out. However, the ratepayers that they looked at trying to recover that money from through the legal proceedings were ratepayers that had significant debt pre-COVID. They weren't looking at anyone that had incurred debt during COVID. It was the fact that they had a significant amount of debt pre-COVID. They were the accounts that they looked at. And one council even sold a property for unpaid rates in provisions with the Victorian Act, okay? As time went on, as I said, past March, April, May, things were also looking that good in Victoria that some metropolitan councils who had passed the long-term resolutions to state a recovery action were starting to ask themselves, had they made that right choice? Because once you set something in stone for a long period of time, you're bound by it, okay? However, as at 1 June 2021, things were looking great. However, the Delta variant in and around June obviously hit. Once that did, and they're still in the current situation at the moment, the councils have backed off all debt recovery action whilst that lockdown was in place. Whilst numbers are going up, and I saw they were going up again today, however, the general consensus, especially in the last week, and the information that we've got coming out, is that especially the councils that are in the rural areas again in Victoria, who haven't been as badly impacted, they're now looking at doing some sort of recovery action. So too are some of the metropolitan councils. Now, the metropolitan councils that are looking to do that type of action, they've made sure that they've already issued their ratepayers with various correspondences and communications such as rate notices, media releases, council website notifications, and local newspapers. So they're really being proactive in getting out there in terms of if anyone's suffering significant hardship as a result of COVID, that they actually contact the council, okay? Moving on to New South Wales. Now, New South Wales was interesting because New South Wales councils, they adopted a similar approach to Victoria. So you had the ones that passed resolutions for a fixed time and those that just had internal policies. However, the state government actually stepped in and they passed legislation. Now, the state government made an amendment to the Local Government Act in New South Wales and introduced what is Section 747AB of the Local Government Act. Now, what Section 747 did, AB, was that it didn't prevent a council from commencing legal proceedings under Section 7112, but it made sure that the council had to consider certain factors before they did that, okay? Now, those factors were A, whether the payment of the rate or charge could be made in instalments or by way of some other financial arrangement. B, whether the person should be referred to a financial counsellor. C, whether mediation or alternative dispute resolution should be attempted first. And D, whether interest on the unpaid amount should be deferred or waived. Now, the original prescribed period for this legislation was due to expire on the 26th of September. As soon as we got to 26th September, that was then extended, and eventually the date was pushed out to 26th of March 2021. So, in addition to Section 747AB, as I mentioned previously, councils had also passed their other resolutions of their own that no further debt recovery would take place until 30 June 2021. So on the one hand, you've got state government passing legislation saying that really you can't go down the legal path unless you're happy to, you've satisfied these criteria. In addition to that, other councils actually passed resolutions. Some did the more flexible approach, others, as I've mentioned, pushed it right out to 30 June 2021. Now, what effect did that have? Well, sorry, I'll just go back one other thing. Most councils in New South Wales, if not all of my clients, they all stopped interest up until at least 31 December 2020, just trying to assist the ratepayers in what they could. Now, in terms of the economy and socially, having family in Sydney and our large client base, New South Wales, and in particular Sydney, pre-Christmas and post-Christmas was doing very, very well. Industry was booming. Again, COVID was under control. Everyone was happy with the economy. The property market was going through the roof. All signals were positive that New South Wales had come out of this and come out of this quite well. What it led to was a number of councils actually looking at doing some form of debt recovery, including legal proceedings, prior to that the prescribed period expiring on the 26th of March. However, most looked at that as the state government wanting them not to take action, so they all decided to hold. What effect did that have? Well, once the 27th of March came, there was a huge influx of work at one time, okay? All the councils that elected to go down that path pretty much moved on it straight away. What it did enable them to do was any of those councils that had that flexible approach, it enabled them to do debt recovery through March, April, May and June before the next Delta wave actually hit. And it gave those councils a significant amount of time to attempt to collect as much debt as possible. And the response from my clients was that the amount of money that's been recovered was significant. And significant to the point that a lot of the other councils who were in that fixed period where they couldn't do any debt recovery up until 30 June 2021 were actually sort of wishing that those resolutions hadn't been passed and they had a more flexible approach. However, come around 30 June, June in this year, those councils that were actually looking to really start their recovery proceedings, again, the Delta variant hit. As a result, as we all know, Sydney's gone into a heavy lockdown, as has most of the state, and all debt recovery in New South Wales has again ceased. Where to for New South Wales? Well, New South Wales, as opposed to Queensland, they have legislation of when they must levy and when their instalments are due. They have instalments that are due on the 31st of August, 30 November, 28th of February, and the 31st of May. Now, with all going to plan, vaccination rates, they're talking about having their day of freedom, that my brother advised me is what they're calling it down there, in October. Now, this is probably going to be way too close to the November instalment, and then again, we're falling into Christmas. So with New South Wales, the effect that it's had is the councils that had that ability back in March 2021 to 30 June 2021 to do that debt recovery and to bring that money in, a lot of them have actually indicated that it's been a real bonus, a real sigh of relief that they were able to at least start something, as opposed to those other councils where there was a fixed period of time and an extended fixed period of time. Those councils now realistically might not be looking at doing any form of debt recovery until March 2022. And that'll be 2 years since the pandemic really came in. So it'll be very interesting to see what the percentages are of some of those councils who fixed the period of time to stay all action, as opposed to the councils that opted for the more flexible approach. Now, moving back home into Queensland, well, I think as we all know, since this pandemic's hit, Queensland has become the place where everyone wants to live, okay? This has resulted in house prices across the state skyrocketing, okay? In terms of debt recovery in Queensland, most councils adopted a similar approach to Victoria. They either passed resolutions at a council meeting that stayed all debt recovery action for a future point in time. Some did it to the 1st of January this year, others did it to 30 June this year, or they adopted an internal policy to hold debt recovery until council saw fit to recommence. Most, if not all, councils either stopped interest in its entirety or they reduced it to a very small rate. Most councils during the height of the pandemic, so really from March, April, May, June, July, August, around September, they were happy to accept any form of payment arrangement with a view that the ratepayer knew that at a future point in time, things were going to have to be increased. One thing, most councils were very proactive in relation to their advertising and letting the ratepayers know that there were special COVID-19 hardship forms and packages that were available. So that was a good thing. Now, as I mentioned before, Queensland, as opposed to Victoria and New South Wales, we've been extremely successful in containing COVID-19. And as a result, Queensland economy is in a much stronger position than that of Victoria and New South Wales. The onflow from that was that the Queensland councils looked to move to collecting the unpaid debt and the unpaid rates a lot earlier than the other states. From my client base, Queensland has obviously been the first state where local government councils has recommenced debt recovery. Okay, the first set of councils to go occurred in November 2020. Gold Coast City Council was my first client, and I had two other regional councils, one a Western Regional Council and a Northern Far North Queensland Council as well. So the fact that Gold Coast City Council was one of the first councils to restart recovery action might surprise some, the fact that tourism plays such a significant role in the economy. However, outside of tourism, there are many industries in the Gold Coast catchment that weren't affected by COVID-19. The building industry, one of them, it is absolutely booming down here. And I think it doesn't matter whether you're in Brisbane, whether you're rural, Sunshine Coast, the building industry has continued to fire, and there is no suggestion of it slowing down anytime soon. So by March, April this year, majority of my Queensland clients who I act on behalf of, who hadn't actually fixed a point in time to 30 June 2021, they had actually got back in to start doing some form of recovery. Okay, I put together some statistics because everyone likes statistics, and just so we could sort of get a bit of an overview of, you know, where things actually stood when the councils actually opened up again. And I did a bit of a cross section. I won't name the councils. I'll just refer to them as Council A, B, C, and D. Council A, obviously one of my larger clients, over 100,000 assessments, recommenced debt recovery or recovery action in April this year. Previously had only done recovery work back in October 2019. Their number of accounts, they were actually down by 30%. But what was interesting was that the average debt was up 35%. Council B, over 45,000 assessments, rural council, just a little bit far north of Sunny Coast. Again, recommenced in April this year. Previous action was October 2019. This time the number of accounts were up slightly, 18%. But the average debt was the average debt referred was again up by 19%. Now, Council C, this was interesting. Council C, Far North Queensland, just over 13,000 assessments. Didn't recommence until July this year. Okay, so not too long ago. Previous action was back in November 2019, sorry. The number of accounts referred to me was down by 43%. But the average debt was up 40%, which is quite significant. Council D, again, just over 35,000 assessments, recommenced in November last year. So this was one of those earlier councils that started the recovery action. Previous action again, November 19. Their number of accounts were only slightly up in terms of the numbers referred, 7%, but the debt value was up on average 32%. Okay. Now, some of the common feedback that I did get from a lot of councils in Queensland is that a lot of ratepayers who were able to access their superannuation did actually use that to clear a lot of those so-called hard accounts, the real ones, the real worrying ones, the ones that were significantly aged. And that was, you know, good to hear. Of my own personal analysis, I had a look at the ledgers that had been referred post-COVID. Well, we're still in COVID, but since we've sort of come out. And it's interesting to see because there was a high percentage of repeat offenders that had actually been with us for our council clients on more than 2 occasions. Okay. The effect that resolutions that when adopted by council can have is that the community become aware of it, and certain people in that community will take advantage of it. Some ratepayers knew that council had stayed the action. They knew that council wasn't doing any debt recovery, and they knew that interest had stopped. And some of them, they adopted the belief or the thinking that, well, nothing's going to happen, so the money's better in my pocket than it is in council's. Now, in terms of which policy works best, well, there's no right and wrong about which policy. I just wanted to make some observations on it. On the one hand, you had the fixed policy by the council. Now, what did that do? Well, that provided the ratepayers with reassurance that council wouldn't be taking legal action against them. One less thing to worry about. I think that was very important at the time. I can understand, especially with some of the Victorian councils that did extended periods of time, is they wanted to give their ratepayers that reassurance that nothing was going to happen. It was one less thing to worry about. Okay, but double-edged sword with that is that if you stay something for a period of time and things improve economically, then you're actually stayed from actually taking any further action. Okay, that happened to a number of New South Wales councils, especially that period where I told you that a number of them did a lot of work between March and June. And it also happened to a number of my Queensland councils. I had some clients who were really looking to start doing some work around March and April of this year, but with the resolutions passed as they were the year previous, they had to wait until 30 June expired. Okay, the feedback that I've gotten is that those councils who adopted the flexible policy were very happy with that. It gave them the ability to assess the situation as at that time. If things were still tough, it could continue with a continuous stay of action, continue to keep interest rates down. It just gave them more of a flexible approach as opposed to that fixed policy. Okay. Personal observations for myself. I did touch on it. Unfortunately, some people will always use other misfortunes for their own disadvantage. Okay. The whole purpose of council introducing policies of hardship and special COVID-19 policies were to help those ratepayers that were struggling. Okay. There's always, as I said, there's always that small percentage of people that they knew what council had passed resolutions to do no action. They knew that council had passed a resolution. They weren't being charged interest, and they decided to say, well, money's better in my pocket than theirs. Okay, I think that had a significant. Well, that was one of the significant reasons that some councils' debt did increase. I especially noticed myself that when we sent out our letters, whether it be the overdue notices or the letters of demand, that there were some significant large debts, but at the same time, there were some significant payments that came in as well, which again was more evidence to show that a lot of ratepayers that elected to hold the money did have the money to pay. They were just waiting for council to actually chase it. I know one particular account, we sent out a letter of demand for 60-odd thousand and it was paid within 3 days. Okay, so that was again just evidence that some people actually had the money and they were just holding on to it. Okay, so that's just one of my observations from that. Now, topic 2, current trends in Queensland. Okay, where are we today? Okay, well, most Queensland councils have restarted some form of recovery action. Okay, on both overdue council rates and sundry debts. As I said, Gold Coast City Council was the first council that I'm aware of in Queensland that commenced some type of recovery action. This took place in November last year. Again, this was despite the pandemic, and that has actually enabled Gold Coast City Council to have an outstanding percentage under 5%, which I'm instructed is also continuing to fall. Okay. Again, at home in Queensland, most councils have been very proactive in making their ratepayers who are struggling and continue to struggle aware that there are COVID-19 packages available, which is a great thing. Okay. Personally, though, I found that, and I think some of the feedback that I also got from my clients was that those people or ratepayers that were struggling, they came forward to council. Okay. They were quite happy to get on the front foot and let the council know what their economic situation was and to work with council into doing some sort of a plan to move forward, which is a good thing. So yeah, it's really Queensland, we've been very fortunate. Sorry, I went a bit too forward. But it's not that we're out of the woods. It's just that we're in a much better position than a lot of the other states. And I'm in such a stronger position that the majority of councils in Queensland have either A, started some form of recovery on their rates, or B, are looking to do it in the near distant future. I only have 1 or 2 clients that are still on hold, okay, and that's the decision of their councillors, and that's fine, that's up to them. But the majority of councils across Queensland have started some form of action to bring the overdue amounts in. Moving on Topic 3, KPIs for debt recovery. Well, really, there's one major KPI, and that's your outstanding percentage. Okay, councils should look to have an outstanding percentage of under 5%. Now, I know we're in a pandemic. We're sort of coming out of a pandemic. Some councils might be a little bit higher than that, and that's fine. But generally, the goal you want to set is to be no higher than 5%. Okay, a good percentage rate would be to be looking at anywhere between 2% and 3.5%. Okay, if you're in that sort of criteria or that schedule, you're doing well. Anything under that, you're doing very well. Okay, so really a KPI indicator, the main one for all the councils and that senior management, especially the councillors, want to know is what is your outstanding percentages. I was just having a think about another KPI that you might be interested in, responding to ratepayers' queries within 48 hours. Now, I don't mean have the whole query completed and done within 48 hours. I know, sometimes there's quite complex things that need to be looked at. What I'm talking about is getting some sort of a correspondence sent back to the ratepayer. It can be even a generic email or a letter, just advising them that their query's been received and it's being looked into. So I think you can agree there's nothing worse than you getting a complex matter, having you or one of your staff looking into it, you're working tirelessly behind the scenes, and just as you're about to get the reply, you cop some obnoxious email from the ratepayer saying everyone's ignoring me, council's not looking into anything, I'm aggrieved, etc., etc. Okay. I'm going to talk briefly now. It's not really a KPI, but I thought it could be, well, it actually is quite relevant. Interest, okay, because obviously interest occurring is going to affect whatever your percentage rate is. Now, obviously, councils charge interest under Section 133 of the Local Government Act, okay. What's important to note with interest, though, is that interest, or Section 133, the purpose of it is that it is a deterrent. It's a deterrent for ratepayers to ensure that they pay their rates on time. It's a penalty. Section 133 should not be used as a form of income. I know previously when I've spoken to some councils, and they've sort of changed the way they're thinking now, that they were quite happy just to let debts increase because at the time they were getting over 11% interest compounded daily. When I was looking at some of the debts that had been referred and people were asking for reconciliations, some older debts that were 4 or 5 years old, the interest component of it was almost half of the debt. It was huge, okay? So I think it's important to note that, council has a duty to collect outstanding rates. Otherwise, there's no point in actually having an overdue date, or sorry, a due date for payment on the rates notice. And 133 is there more as a penalty, as a deterrent, not a form of income. And if anything, the case of Brisbane City Council versus Amos, which I'm not going to talk about that today, but that's a further reason that council should be very careful in monitoring any properties where rates and charges are getting close to the 6-year period. Obviously, in that case, the court made the decision that council has a 6-year statute of limitation to commence legal action against the recovery of rates. So in terms of the KPIs, obviously the main one is what's your percentage. Look to keeping it under 5%. I know we're in a very different economic climate at the moment, and that 5% might not be achievable for some councils. But as things gradually improve, and again, fingers crossed with the news we're getting today, it will continue to improve. Look to keep your KPI, your under 5%, your outstanding percentages. If you can get it to around the 3.5%, you're doing well. Anything less than 2%, you're doing really well. Okay. The next thing I wanted to talk about, important topic, especially with COVID, is hardship. Okay. I'm not here to talk about whether you should or shouldn't have a hardship policy, whether or not you have an application form that's sufficient, or whether you just get the ratepayer to fill out their details in an email. What I'm talking about is if assessing someone's hardship, and just a few pointers and things over the years that I've become aware of, and just things that might help you out, because I don't think hardship's going away anytime soon, especially with COVID. okay? And I think a few little things that I'll talk about here might give you a few tools to add to your arsenal when responding to ratepayers. First and foremost, I think a lot of you will know this, but hardship should only apply to ratepayers' principal place of residence. It's amazing over this 20-year journey that I've had, especially with local government, how some people, mainly property developers, who own not only multiple properties in their own name, but in companies and trusts, seem to think that just because things aren't going so well and the multiple properties that they own aren't at a significant dollar value where they should be, that they're suffering hardship, okay? A court will always look to see if there are any assets, such as additional real property, that could be sold to pay off the debt. Now, the reason I'm going to talk to you, why I've included this of what the court will look at, is those that work in the rates department especially will know, some ratepayers out there like to use threats. They like to use threats that they're not happy with the way that councils commence debt recovery and they're going to the media, or they're not happy with the fact that council won't accept the instalment offer that they're making, so they're going to go to court. The court's going to grant whatever they want. Unfortunately, that's not correct. Not always going to be what they think it's going to be, okay? Most courts will look to having a debt paid off between 9 to 12 months. I know when I first started off in my legal career, I cut my teeth for many, many years doing things what we'll call application to pay by instalments, okay? Now, this was scenarios where debtors would come to the court, the instructing client wouldn't be happy with the offer that they've made, and they would go into the court to seek an order, okay? Most courts would allow between 9 to 12 months to pay the debt off, which to some ratepayers could be significantly shorter than the period that they're actually thinking or that they're after, and could actually be significantly shorter than the period that council is actually happy to accept. So what I'm sort of saying is, don't feel threatened just because someone's going to say to you, I'm going to go to the court. And don't think just because they are going to go to the court that they're going to get this huge extended period of time to pay the debt off. The court has a duty. They'll look at both sides, both the plaintiff and the defendant, and they're going to try and fit a balance that suits both parties. So, yeah, just be mindful in relation to that. When you're assessing a hardship, okay, you should not accept an instalment application where there is a surplus between the income and the expenditure, and the instalment offer does not total the surplus. Layman's terms, what does that mean? You might have a ratepayer that will come to you and list their income of $1,000 a week. It might be a joint income with them and their spouse, de facto partner, etc., etc. They'll then list their liabilities of $800 a week, giving a $200 a week surplus. That $200 a week is what you should be asking for them to pay, okay? Quite often, especially when I was in court, the common thread would be, and again, I'll go back to that $1,800. Oh, I've got I've got 200 a week left in my pocket. I've got to have something to live on. Well, no, that something to live on should have been factored in to all of their expenses, okay? So really what they would be left with at the end was an amount of money of their income less their expenses, and that is the amount that council should be looking to recover, okay? Vice versa, some people who are trying to pay the money off think that if they list that their expenditures far outweigh their income, that the court or the party the offer is being made to will feel sorry for them and accept it. Well, I can tell you now the court won't, okay, and neither should council. All right, so if, say, for example, and I'll go back into a very general example, someone has an income of $1,000 a week combined, and they then list their liabilities $1,200 a week, and they want to pay $50 a week. Well, if it was in front of a court, the first thing the court would say, well, you've got no capacity to pay. Where are you going to get that $50 a week from? Okay, so don't be too afraid if you have a ratepayer that tries to put the pressure on you and tries to list expenses that are greater than their income, and then tries to make some threat saying that they'll go to the court, because the court will simply look at it and say that, you know, sir, madam, you actually have no capacity to pay, so I can't make an order to that effect. Okay. When looking at hardship applications or the details that they'll be provided if you don't have an application form, a few tricks over the years that I've always seen: always add up the expenses yourself. It's amazing. You might have people that will list, 30 different expenses, and they might go into great detail, and at the end they'll have this figure. And when you actually go into the, you go in and you add it all up, it's actually not the figure that they've actually put on there. So just a few little tips there. Always double check that the figures that they're giving you are correct and that they match. Okay. My experience, always ask for bank statements, proof of income. Most people, or sort of say most genuine people, are happy to provide this type of information. Okay. I've always found, and experiences always shows, that it's the people who have something to hide are the people who are not willing to provide that documentation. Okay. One thing that you might want to make a note of, whether or not you've got a hardship policy and a hardship application that you use that might be beneficial, there's a document called a Statement of Financial Position, Form 71, Queensland Magistrate Courts form. Okay. I've put the web address that you can get to it, www.courts.queensland.gov.au/about/forms. It's the Form 71 under the Uniform Civil Procedures. When you go to that page, there's a lot of forms. So look for the Form 71. Just be careful, there's an online part. You actually want the Word document. Really good tool, really good document to have a look at. Goes into very significant detail questionnaires about a debtor that where an enforcement hearing summons might be taking place, making them list their, all different types of incomes that some councils might never even thought about thinking about asking. Okay, shares, monies in trust, things like that. Now, I'm not saying you have to use it all, but if you're looking at doing a bit of an update to what you've currently got, or you're looking at actually putting a policy in place from scratch, the Form 71 is a really good document to have a look at. It goes into significant detail. I'll give you that warning. So I don't think you need to put every single question on there, but in terms of doing a bit of a refresh and probably for your governance, have a look at Form 71. As I said, under the Uniform Civil Procedure rules, it's a really good document to use. Okay, so yeah, in relation to hardship, always principal place of residence. Okay, don't be scared off by people saying that they're going to go to the court. It's a bit like people that also make threats to you to say they're going to go to the media. Most of the time they never do. Okay, and yeah, just make sure that you always check the figures that they're giving you, that they match, and don't ever be afraid to make sure that you ask for whatever the surplus is, that be paid to council, because that is the whole purpose of the function of that exercise. Moving on to our last topic, sundry debtors. Now, as I mentioned before, obviously the first thing councils think of is rates in terms of bringing percentages down, and rates have continued to be levied throughout the pandemic. But sundry debtors can be equally as important. Some significant debts can be raised as a result of sundry debtors, whether it be trade-based, commercial leases, compliance notices that have been issued and not complied with, and councils have to go and do the work. Okay. Unlike rates, which is fairly straightforward. Okay. So the recovery of an unpaid sundry debt or accounts receivable can be quite challenging. Okay. And the reason is, by the time that debt has actually been referred to the finance department, the processes that council should have conducted to establish the evidence that you need will have come and gone. Okay. The old saying, the horse is bolted. You're relying upon some other department doing what they needed to do to have given you the information that you need to be successful with. Okay. Unfortunately, some departments aren't aware that just raising a tax invoice is evidence of the debt themselves. I hear it all too frequently that the department that asks the finance department to raise the debt says, well, here's the invoice, raise it, go and collect it, there you go, you've got what you need. Unfortunately, it just doesn't work like that. As a plaintiff, and the council is always going to be a plaintiff in this situation, council bears the onus of proof in establishing both liability and quantum. Okay, council must prove that the party is liable for the debt, as well as prove how the debt is calculated. Many times I've seen situations where councils have been able to prove the liability of the debt, but then unable to prove the quantum. If you can't prove both of them, you're not going to be successful. Vice versa, I've seen situations where councils have been able to prove the quantum or the work that was done, but they've fallen short on the liability factor and enough evidence to prove that the debtor was actually liable for it. So it's very important that you actually provide both of those two things when you are trying to collect a sundry debt. Now, in terms of liability, as I said, council must prove on the balance of probabilities that the debtor has a legal liability to pay the council the debt owed. Okay. Liability might be evidenced in the form of a written document, such as a contract or an application form, or it might be a statutory liability, such as issuing a notice to comply. Okay. Quantum, and again, tax invoices, they are important, but they're not the be all and end all. Once councils prove liability, and you first must prove liability, it's still going to prove quantum, and that is the amount of the debt is actually owed to council. Examples of this, again, would be where the tax invoices are issued, but also that the tax invoice is correct. And I'll go into a little bit more detail, but things such as council's fees and charges, that whatever the tax invoice is issued for, it actually mirrors exactly what the fees and charges have been adopted for that financial year. Now, I'm going to give you 3 examples talking about sundry debts. I'm going to keep it generic. Okay. One example, most, if not all councils, or a lot of them, have trade waste facilities, tipping stations, the old tip. Examples of the evidence that you need for liability for a debt that relates to a trade waste facility: a signed application form, executed correctly. An example of this, it might be a company. Has the director actually executed the document on behalf of the company? Or has it just been an employee that actually has no right to sign that document on behalf of the company? One of the things I'd always do, especially when it's a company, is, and there's an application form, is make sure that you get hold of the company search, just so you've got the evidence, and then attach that search to the file, especially with the form, just to prove that the person who is actually executing that document has the authority to do so. Okay. With this example, it might be that you need signed authorization forms of vehicles who have permission to use the facility. Okay. I've seen it time and time again where there'll be an application form and there'll be 2 vehicles put on it, 2 trucks. Over time, this association or this contract with council could be going over many, many years. That particular entity might get another 2, 3, 4 trucks, who knows. You want to make sure that each and every time that there is a new truck or a new vehicle that is going to be used at the facility, that there's an authorization form. Because this is really important when it leads on to the next point, and that is you're going to need a copy of all the waste dockets. All the dockets that when the truck or the vehicle turns up, that shows how much, or the date, the time, the weight, and the vehicle that was actually used at that point in time. Okay, so that's the liability for trade waste facilities. In terms of the quantum, well, you're going to need to keep a copy of all the tax invoices. Okay, very important. Now, even more important than just a copy of the tax invoice is you're going to go behind that. You have to then have the evidence to show that that tax invoice has been charged in accordance with council's fees and charges for that particular year. Okay. In terms of evidence in court, you'll need to provide a copy of the council fees and charges for that year, as well as the council resolution that it was adopted. Okay. So it's not just a case of here's the tax invoice. Okay. Very important, the tax invoice, but you've then got to show that the tax invoice actually matches the fees and charges for that particular year. A second example of a common debt for sundries or accounts receivables, collection of outgoings from a lease or a lease itself. Okay, in terms of the liability, to show the legal liability, you need a correctly executed lease. Unfortunately, there's been times over the years where the lease has been supplied and it just simply wasn't, the copy that council hasn't even been executed, A, at all, or B, wasn't executed by a party that had the authority to do it. Okay, you need to make sure that the lease is in the name of the correct party who's attempting to collect the money from. Okay, again, I've seen scenarios where the names on the lease, and I'll say, for example, Mr. and Mrs. Smith, that was who was on the lease, but council was actually attempting to collect the money from Mr. and Mrs. Smith in a business name. Okay, that's two different things. Okay, you've got Mr. and Mrs. Smith in their own individual capacity and Mr. and Mrs. Smith trading as the business. So it's important to make sure that whoever is listed on that lease is the correct party. Okay, so that's obviously a governance thing as well. Okay, don't mean to scare anyone. Go back and start looking at all your leases and things like that. But moving forward, you should always make sure that someone with the appropriate legal capabilities probably looks over the leases and make sure that they have been executed correctly. In terms of proving quantum for the outgoings of a lease, again, you need a copy of all the outgoings, such as could be the electricity bills that received or the gas company. You then need a copy of all the tax invoices that were issued by council, and you've got to make sure that those tax invoices have been issued in the correct names. Okay, and this is where I'm getting back to making sure that the lease has been executed correctly. I've seen situations where the lease was in the name of the individuals, but the tax invoices to get the outgoings has been in the name of the business, and that was wrong. So we then had to reissue the tax invoices back into the names of the parties on the lease to be able to council to move forward. Now, I know these might seem quite simple, but it's amazing how often that simple mistakes can occur. Okay, so especially with leases and outgoings of leases, always make sure that you've got the correctly executed documentation, sorry, the correctly executed lease and the documentation to be able to back yourself up. Thirdly, and this is quite common in accounts receivable and sundry debts, council might issue a remedial notice. The ratepayer responds to act in accordance with that notice, and council takes the appropriate action. Okay. In terms of the liability, establishing liability, you have to ask yourself, has council issued the notice to the correct parties? Okay. Has council drafted the notice correctly? Has council served the notice on the relevant parties? And has the time for compliance of the notice expired? Unfortunately, I've had situations where notices were issued in the names of two parties, only one party was served. The particular council then sought to issue the tax invoice against both parties and then was looking to recover the money against a party who had actually never been served with a notice. Okay, so it's important, especially with these compliance notices, that you have dotted your I's and crossed your T's and make sure that they are absolutely perfect. I've had a situation too where unfortunately a compliance notice was issued. That particular notice, the time for compliance did expire and that was fine. However, we later found out that there was a second notice that was issued, and from memory the compliance period was 14 days. I wasn't made aware of that till just before we were on the court steps. And the second notice that was actually issued, compliance period actually hadn't complied. Only 11 days had expired and they'd actually gone out and done the work. So it's critically important that with any type of notices that the period for compliance has actually expired before council does any work. In terms of proving quantum for similar type debts, are the tax invoices made out to the same parties in the notice? Does the tax invoice match the work that was described? Does council have all the receipts of any contractors who may have carried out the work as a result of a notice? Very important, okay? Council may need to use a third-party contractor for any particular reason, and then obviously council will issue the tax invoice under the banner, under the council's name, but to be able to prove that, you are going to need the evidence that the third party actually did the work, invoiced council, and council has paid for it, okay? Again, this might seem quite simple, but you've got to make sure that the amount charged on that tax invoice is the same amount that has been charged by the contractor. Okay. Lastly, has council charged the tax invoice in accordance with the fees and charges for that relevant year? Okay. It might be, and I've seen in the past examples where council staff have had to go out and do work as a result of a notice not being complied with. There's been an hourly rate for the council staff. You just got to make sure that whatever is being charged matches council's fees and charges for that year. So if the council staff or the member is charging out at $22 an hour, I'll use that as an example, and you just got to make sure that that amount is what is reflective on the tax invoice. I have seen, unfortunately, where errors have made that contractors have been actually charged out more than what was in council's fees and charges for that year. So obviously the claim for that amount had to be reduced. Okay, so in relation to sundry debts, just recapping, you are reliant upon what council, other departments have done before it gets to you. But I think it's even more important now, especially the fact that council during the pandemic has probably not chased sundry debts as well as rates, is that you're probably going to find that there's a bit of a backlog, okay? I always make sure the worst thing you can possibly do is give instructions to any lawyer or debt recovery agent to issue a claim based on a tax invoice for a sundry debt. You really need to make sure that you have got all the evidence to prove both liability and quantum before the claim is even issued. Any competent lawyer will make sure you have that, because there's nothing more embarrassing I could imagine than you going to court and then you don't actually have the material or the evidence that you need. Okay. Moving on, especially with sundry debts, probably the last point, you have to ask yourself, the big question is, you might have all the evidence that you need for quantum, and you might have it all for liability, but what are the prospects of you actually being able to recover the debt? So as opposed to rates, which are a statutory charge on the land, you actually have an asset that will eventually be sold, okay? If you take legal action, you get a cost order or judgment, rates, the costs go on the land, you'll eventually be paid. It's not the same. Sundry debts primarily are an unsecured debt. So you've got to ask yourself a few questions, and I always say this to some of my clients, because we could have all the information and documentation we need to be successful. Is the company trading, or is the debtor still trading? Okay. If it's a company, is it a $2 company? Does it have any assets? And that's sometimes very hard to work out. Okay. Has the debtor skipped town with no known whereabouts? This is probably easier for rural councils because metropolitan, obviously they're larger, but at the same time, you've got to ask yourself if they've gone, especially as rural. I know this with a lot of my clients, they've given me debts to collect, and even though we might have the information, I say to them, well, do we know where they are? Obviously you check to see if they're bankrupt, things like that. Because really, I often say to my clients, you don't want to be throwing good money after bad. Okay, and that's really the hard thing with sundry debtors. You might have all the evidence yet that you need to satisfy it, but if you're going to have to go and spend the $600-700 minimum to file a claim in court, you want to be able to make sure that you know where they are to be able to serve the document in the first place. But even if you get the judgment, you really want to be satisfied that you've got a genuine attempt to be able to collect that money. Now, I know that there's now credit rating things where people that have judgments against them are affected for 5 years. If you're a director of a company and the company has a default judgment, then as a director, that goes on your credit history as well. But what you've got to realise with some people is that if council's chasing them for amount of money, chances are that quite a lot of other people or entities are probably chasing them as well. And if they've got one judgment against them, they're not going to care if they've got 2, 3, 4, 5 or 6. So really with sundry debts, you've got to ask yourself the question, what's the likelihood that we're going to be able to recover the debt? Okay, sometimes it can be a really hard decision, and you might come to the conclusion that although it's a significant debt, that there's little to no chance of recovering any money. But that's only a decision that you can make. Okay, so in terms of collection of sundry debts, as I said, by the time the matter gets to you, you're relying upon other parties having done what they need to do. Again, just make sure that you've got all the evidence that you need before the claim is even issued at court. But then also have a think about it too, that just because you've got the judgment doesn't mean that's any guarantee that that's going to be paid. Okay. Moving along, the future in COVID. Well, it was funny, as I was putting all this together, it was before what actually is probably already happened in a press conference as we speak. We're naive to think that as a community, we're not going to be subject to future lockdowns. We don't know what future strains are coming out. It's going to be interesting in the future to see, what actually happens, whether the councils who, adopted to pass those fixed long-term resolutions to stay all action will actually revert back to a more flexible approach where, although everything is stayed in terms of recovery action and although interest might be stopped as well, that it actually just gives council a bit more flexibility to be able to start recovery work if things become good. And probably that's the most important thing when looking at any of those policies, because none of us have a crystal ball. None of us know when the next outbreak is going to come or what might happen. And I suppose the policy that I think is probably the better of the two would be the flexible one, because it just allows council that ability that if things do become good at a point in time, especially economically and socially, and everything's going really well, the council's got the ability, if it wants to be able to move forward to try and collect some of that debt. I know some of the councils, especially in New South Wales and Queensland, would like to have commenced some of that debt recovery work when things were going really well, but because they were fixed in with resolutions that were set till 30 June, they couldn't move forward. Okay, so that's it from me. I don't know whether or not I've gone a little bit too long, Michael, but you'll be able to tell me. But look, if you've got any questions, please feel free to pass them through to Michael. Happy to get back to you in due course. Otherwise, you can always get in contact with me. Happy to have a chat at any time. Hope you got something out of it. Where COVID actually, what we all did when COVID commenced, how we've gone through it to where we are now, and hopefully a future is a brighter one. So, but also in terms of things such as hardship, hope you got a few tips out of that. That Form 71 is a really good document if you're looking at amending your hardship policy or you're looking at doing one from scratch. Okay, sort of recapping again, please don't get too intimidated by ratepayers that say they'll go to the media or they're going to go to the court in relation to hardship payment instalment applications, because they probably would be quite surprised that the court may actually give them a lesser period of time than council would have been prepared to accept. So again, thanks for your time. Happy to answer any questions if you want to send them through to Michael, and stay safe.
And thanks, Nick. That was a really comprehensive session. I think we learned a lot out of that in terms of some key takeaways. But just quickly for everyone, just in terms of the notes I took out of that session from Nick, obviously internal policies on deferring rates is a more flexible option for councils, and you don't get locked down then into longer periods of non-recovery than you need to be in terms of the changing environment with COVID. Councils in Queensland have, a lot of them have already started their recovery actions again because of our current, the way we've handled the outbreaks up here and relatively unscathed compared to down south. Regarding KPIs, some interesting stuff from Nick there around looking at are you actually measuring and monitoring your targets for rates of arrears, particularly as Nick mentioned, 5% max. Are you reporting on those to your council every month? Are you targeting a lower rate than that, 2 to 3.5%? Nick says it's probably a good range to target, so good thing to think about. Setting KPIs, which you may already have in terms of your customer KPIs around answering queries from ratepayers. Monitoring arrears, and particularly that 6-year issue with Brisbane City Council we're all aware of, so actively monitoring your arrears balances and taking action accordingly. As Nick just mentioned, your hardship policies and approaches, reviewing those. Are you best practice there? Are you checking figures? Are you asking for supporting evidence? So good takeaways there, Nick, thank you. And sundry debtors, which is always a challenge for councils. You know, what's the cost benefit of collection there? Do you have, do your areas, because sundry debtors go across the organisation, do those areas that are charging for invoices, your waste areas, leasing property areas, is that information, are they keeping good records so that in the event that you have to start collection, it's, as Nick mentioned, your compliance notices, are they, you know, being produced? Are they perfect? Are they current? So look, overall, I think, Nick, really interesting session. Thank you. Very topical, of course. We're all in that boat in terms of collecting, particularly rates arrears and the pressure we are under politically and organisationally to provide flexibility there. So it's good takeaways for the audience there. And just to wrap up, everyone, thanks for your time. Our next webinar is on the 28th of October, where we're looking to partner with Resource Analytics on full cost pricing for local government waste businesses. So I encourage you to, if you have an interest, to jump on that webinar. At the end of this session, there'll be a quick survey to complete, and we appreciate you doing that to give us some feedback on how you think the webinars are going. That'd be great. The other quick one is our conference registration is now open. Our annual conference will be held in Cairns in November 23rd to 26th. Go to our website for details and the registration form there. And just a quick wrap up, thanks for your attendance, Nick. Appreciate the session and appreciate your ongoing support to the LGFP. And we'll see everyone at our next webinar in October. And bye for now. Thanks.